Hello, everyone, and welcome to another employment law Q&A. My name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin, LLP, and we are here again for the next half an hour answering any and all questions our viewers have with respect to your employment. Whether you're dealing with a difficult situation with a boss or a coworker, at work, maybe you're feeling bullied, maybe you're feeling harassed in the workplace, or perhaps you're dealing with a termination. Maybe you've been let go from your job and you're wondering whether the severance offer that the company has made is reasonable or not. Or if you're dealing with a medical issue at work, maybe you're off on a medical leave of absence, you're receiving disability insurance. We can also answer any questions related to medical leaves of absence, disability insurance. That's certainly part of the conversation as well when it comes to your employment rights and your disability rights. Really, any questions under the sun when it comes to your workplace issues, any issues that you're having, we are here to answer and address those concerns. Before we get into things, and there are a couple of matters that I wanted to talk about today to kind of get everyone's thoughts flowing and get some questions lined up. I wanted to share our contact information. If you'd like to get a hold of us, the first place you should visit is our website. Employmentlawyer.ca is where you can find us. That's employmentlawyer.ca. It's on your screen right now. That should be the starting point. We've got a ton of resources on the website. We've got articles, blog posts, lots of video clips that you can watch very quickly. If you're dealing with any particular issues at work, that should be your starting point. Go ahead and visit our website, look through the various clips and whatnot. Of course, we have our contact information on the website as well. It's a great starting point. You can also email us, however. If you want to send us a quick question, if you're dealing with a situation at work, send us a brief email, a couple of lines describing your situation, basic details at help@employmentlawyer.ca. help@employmentlawyer.ca. Again, it's on your screen right now. Do not be shy to send us an email at that email address. I promise someone will get back to you to answer your questions or to put you in touch with an employment lawyer that you can speak in more detail to. I cannot tell you guys how many people we help through our website, through our email address. We are put in touch with people every single day that contact us with particular questions about their specific situations. So again, our website, email address, of course, if you want to, we have a number that you can call that's on our website. We can put it on the screen right now as well. If you want to give us a call as well, leave us a message. Make sure you speak with someone in our intake team. Feel free to give us a call as well. Do not be shy to do that. You can call us at the office. We have an entire team of intake people to speak to answer basic questions, and ultimately, again, to put you in touch with an employment lawyer. To get us started today, I wanted to talk about a particular matter dealing with severance that actually came across my desk recently. It was actually an article that was published in the Toronto Sun about a case of a long service employee who had worked with IBM actually for many, many years. This was a 38-year employee who was let go and offered an insufficient severance package. This particular individual was 62 years of age when they were let go, so in their early 60s, and again, had been with the company for 38 years. I mean, that's obviously a tremendous period of time, a remarkable period of time. And I wanted to share this information in the story of this case, not because it's rare or because it's kind of the exceptional case, because these are situations that we actually see day in, day out when it comes to severance negotiations. And it's a reminder to everyone out there, everyone that's viewing this right now or is viewing this in the future, it's a reminder that if you are ever let go from your employer, do not assume that your employer is offering you the correct amount of severance. Do not assume that what your employer is referring to or is telling you is necessarily legal or correct. Do keep in mind, and I don't mean this cynically, I don't mean this in any kind of conspiratorial way. Keep in mind that at the end of the day, when it comes to severance, an employer is going to want to pay as little as possible. The employer is looking out for their own interests, right? And making sure that they meet their minimum legal expectations, but do really no more than that. They're looking for a good deal for them, for the business, for the employer when it comes to severance. And this particular case is an example of that. This particular individual, who was again 38 years of service with the company, was 62 years of age when they let go, and I think they were in kind of a lower to middle management level position with the company. This individual ended up getting 27 months of severance, not weeks, months of severance. That is 2 years plus 3 months of severance from a court in Ontario. A tremendous severance package, obviously, 2 years of pay, really, for having been let go after all those years of service. Generally speaking, 2 years is a bit of a limit or a cap on severance. But because this individual had been with an employer for so long, and again, because of their age, because of their years of service, and because of their position within the company, this person actually broke that ceiling, broke that cap, and actually ended up receiving 27 months of severance, so slightly more than that general cap, which is typically reserved for, again, long service employees, older service employees. And I guarantee you that that individual was offered far, far less than 27 months when they were initially let go. Again, IBM, and generally speaking, most employers in these kinds of situations, even for long service employees, even for older employees and management level employees, will try and get away with paying as little as possible. Right? And the lesson here for all employees out there should be, do not assume that what your employer is offering you is correct. Make sure you speak with an employment lawyer, as this individual did in their case, right? And make sure that you are receiving a severance package that is aligned with what you are rightfully owed based on your age, position, and years of service. Those are the three main factors that are taken into consideration when assessing an employee's severance entitlements. Right? Your severance entitlements are not 1 week per year of service or 2 weeks per year of service. They might even be more than 3 or 4 weeks per year of service, right? Because it is a context specific scenario where each employee's circumstances are going to dictate, based on their age, position, and years of service, how much severance they're going to receive. And sometimes it could be as much as 2 years of pay. And in this case, it was actually more than 2 years of pay. Again, this is not, the rare case. This is not the extreme case. That is the correct amount of severance for that individual, right? And what we see quite often is that employers are offering far less than what employees are actually owed. If you find yourself in that situation where you're being let go and offered severance, or if a colleague, or if a friend, or if a family member is being let go from their job, make sure that the severance that they're being offered is appropriate. Give us a call at the office, send an email at help@employmentlawyer.ca. Let's review that severance package together. If the severance offer is fair, great. We will give you our blessing. We will let you know that it's fair. You can sign off and move on to new employment, hopefully. However, unfortunately, far too often, we see employers that are offering less than what an employee is actually owed. I guess the good news in that respect is that these issues of severance negotiations and severance calculations aren't overly complex. This is not complicated law. Oftentimes, with very little effort, we can convince an employer to pay up and pay the correct amount of money to employees. So again, send us an email, give us a call. If you're looking at a severance package right now, if you've been let go from your job, do not sign on the spot. Do not sign off on that severance offer without making sure that you speak with an employment lawyer first. And this case is an example of that. Okay, I see a couple of questions lined up, a couple from YouTube, one from Facebook. Just as a refresher and reminder here, once again, for those of you just tuning in, this is a live employment law and disability insurance law Q&A. I am here to answer any and all questions related to your workplace issues, whether you're dealing with severance or you're dealing with a difficult work environment. Maybe you're dealing with changes to the terms of your employment. Your boss is asking you to change position or accept a different compensation structure, and you're not sure what to do. You're not sure how to respond to your employer. Or if you're dealing with a medical leave of absence and maybe an insurance issue with your insurance provider, This is your opportunity to speak with an employment lawyer, ask your question, and get those questions answered. I promise those of you who ask questions, I often get emails after these live Q&As thanking me for my efforts, thanking for asking that questions, and sometimes that leads to future conversations about further recourse that those employees have. But again, once again, my name is Alex Lucifero. I'm an employment lawyer, partner with Samfiru, Tumarkin, LLP. This is a live employment law Q&A. If you haven't already, go ahead and post your question right now. We are starting the live Q&A version. I'm done with my case of the day, as we call it. And so let's get started. Creighton is first in line on our Facebook stream. And Creighton asks, I work 2 part-time jobs and recently had to take a shift off as I was sick. My other boss is now angry that I have another job as a co-worker mentioned it to him. Is it actually illegal to work 2 jobs? Creighton, it is absolutely not illegal to work 2 jobs. Your boss can be angry all he wants. If you are meeting your obligations when it comes to that particular job, then there's nothing your employer can do in response. Now, make sure, Creighton, in the situation of a couple of things. Number one, you want to make sure that there's no conflict of interest here. So I might be stating the obvious, but you want to make sure that if you're working in 2 jobs, that those jobs don't conflict, right? You can't really be working for example, 2 competing companies. If your work with one company, let's say as a salesperson, for example, is going to compete with your work for the other company also as a salesperson, perhaps selling the same products, that would be a conflict of interest, right? And you want to avoid situations like that. That might be a breach of your kind of implicit obligations to the other employer in that kind of case. That's kind of the most obvious example of how 2 jobs may conflict. If you're not in a conflict of interest situation in that way, then again, you can absolutely work 2 jobs. And certainly any employee is allowed to call in sick from work if they are well and truly sick. Sometimes it's useful in those situations if this is going to be a bit of a prolonged absence. Let's say you're dealing with a very bad cold or some sort of infection or some sort of prolonged health issue. You may want to schedule an appointment with your doctor and actually get a doctor's note confirming that you're ill. That is a bit of protection. And sometimes you could send that note to your employer. That might be a bit of protection that you can use, right, to ensure that you have evidence that you're sick. If you provide a medical note to your employer, that gives you extra protection. Your employer cannot let you go if you're on a medical leave of absence. They cannot punish you in any particular way because you've had to take time off because you're sick. That may very well be considered discrimination on the grounds of your health status or on the grounds of disability, as we call it. In Ontario, at least, and in Canada more generally, terminating an employee because of a health issue, because of their medical status, is going to be considered discrimination under human rights legislation. You cannot let an employee go. You cannot punish them. You cannot either demote them or change their compensation or dock them pay because they are ill. That would be considered discrimination, right? And an employer in that situation is going to actually owe that employee damages for discriminating against them. And that is not a situation that an employer is going to want to be in. You don't, and if you have any employers right now, or any HR representatives, or any management level employees that are watching this right now, you want to make sure when you're dealing with employees who are either calling in sick from work or dealing with a health issue and taking a medical leave of absence, those employees need to be treated with velvet gloves. You have to be very careful with employees dealing with disabilities or dealing with medical issues. You cannot simply end their employment. You cannot simply brush them aside if they're medically unable to work. It is not that easy. Those employees have enhanced protections and have enhanced rights when it comes to employment law. And so be very careful from an employer's point of view dealing with those employees. From an employee's point of view, you want to make sure that, again, if you're dealing with a medical issue, if you're having to take a medical leave of absence, make sure that you have your doctor's support in confirming that leave, and make sure, just as evidence is key in these situations, make sure that you have evidence in the form of a doctor's note that you can then share with your employer confirming that it's a medical leave of absence. Once you do that, your employer has to back off. They can't bother you any further. All right, Creighton, thank you very much for the question. Listen, if you have a follow-up to that, if you wanted to get into any more detail, don't be shy to post a follow-up. More than happy to answer that question. Next up, however, is Isaac on YouTube. Thanks for tuning in, Isaac. He asks, can I be terminated when I sue my employer for discrimination and defamation for giving unsatisfactory reference which does not reflect my person? Isaac, interesting question. You can certainly sue your employer for discrimination and defamation potentially if your employment has been terminated, or if in the context of your employment, if you're still employed, if you feel as though you've been discriminated against, right, and defamed, yes, you can actually sue your employer in a situation like that, or at least if you're in Ontario, or most likely any other province in Canada, you can also file a complaint with the Human Rights Commission in that particular province. Or if your employment is federally regulated, you can file a complaint with the federal in Canada Human Rights Commission. So you can file a human rights complaint effectively against your employer. Now, if, Isaac, your employer terminates your employment in response to your claim of discrimination, that is very likely. And if those two dots connect very clearly, right? So if you file that discrimination complaint, and lo and behold, not long after your employment is terminated, right? You can connect those dots pretty easily. And it's likely that your employer did that in response to you raising those concerns or filing that human rights complaint. That is going to be considered what's called a reprisal. Reprisal is illegal in Ontario and in Canada more generally. Again, and I was just making this comment, as I'm sure you heard, your employer cannot punish you for raising concerns about human rights issues. So whether that was discrimination on the basis of disability, or perhaps on the basis of age, or gender, or nationality, or race, there are, of course, a number of protected grounds for discrimination, right? If you have raised concerns in that respect and you are being punished in response, again, that may very well be a reprisal. And you're not only, because it's a termination, of course, would you be owed severance in a situation like that? If ultimately the discrimination is proven, you would be owed additional damages for those claims for that discrimination. Isaac, if you haven't already, and you're in this situation, it seems like quite a difficult one. Of course, I'd make sure that you speak with one of our employment lawyers. Make sure that you're getting proper legal advice from an employment lawyer. There are, of course, lots of nuances in these kinds of situations. The advice that you receive has to be tailored to your specific individuals, your circumstances, exactly what happened in the context of your employment. You mentioned defamation in your question. Keep in mind, defamation is something very specific, right? So if you're pursuing a claim for defamation, you want to make sure that you actually meet the legal threshold, the legal test for that kind of claim. Again, give us a call at the office, send us an email at help@employmentlawyer.ca. Let's get in touch. Make sure you speak with an employment lawyer, and let's make sure that you get proper advice in the circumstances. But thank you very much for your question. Much appreciated. Moving on, Trent on YouTube as well asks, are you still owed your bonus if you've been let go before it's given out? I was fired about a month before. Excellent question, Trent. It's one we get very often. I probably speak to people almost every single day about this specific issue. And here is the way it works when it comes to bonus, Trent. As a starting point, as kind of a default position, if we could think of it that way, an employee who is let go and is owed severance is going to be owed all components of their compensation over the course of the severance period. So that means base salary, it means bonus, it means benefits coverage, it means pension contributions. If you're receiving a car allowance, it would include a car allowance. And so the real question, Trent, here is how long is your severance period? If your severance period extends several months, right? If you're owed, for example, 6 months severance, right? Then the real question is, well, you should be receiving full compensation for that 6-month period. So if your bonus was due to be paid in a month's time, right, a month post termination, shall we say, then 100% your bonus should be included in the calculation of your severance entitlements. Because again, it's a question of how much you would have received, how much you were owed over the course of that full month, full 6-month period of time based on all components of your compensation. Now, there's one little caveat here, Trent, that I'll get into because we have the time. There's one little caveat that I want to mention when it comes to things like bonus, things also like stock option units or stock or restricted stock units, as they're often called. So these kind of other significant components of compensation. I'm not talking benefits or pension. Those are usually the easy ones that automatically have to be included. But when it comes to bonus, it is also important to look, Trent, at any bonus plans or bonus agreements, or even to have a look at your employment contract when it comes to your bonus entitlements, because really the only way in which an employer cannot pay bonus as part of an employee's severance entitlements is if they have language in an employment contract or language in a bonus plan or in a bonus agreement that very clearly and very specifically says that bonus should not form part of an employee's severance entitlements. If you have a contract of employment, Trent, that very clearly, very specifically says that bonus isn't included in the calculation of severance, well, then your employer may be allowed to rely on that contract to limit the severance calculation and not include bonus as part of that calculation. That's really the only way in which an employer cannot pay bonus as part of an employee's severance entitlements. If that language in that contract doesn't exist, or if there's no bonus plan that's kind of documented, and an employee received bonus as a regular part of their compensation every quarter or every year, etc., right? And again, there's no contract in place that limits an employee's entitlements in that respect, then absolutely bonus should be included in the calculation of severance. And as I previously stated, when we're talking severance, we're not just talking about a base salary calculation. It's really all components of an employee's employee's compensation package, rather, that should be included. We will very often negotiate severance packages based on compensation packages that include overtime pay, that include standby pay, for example, for technicians and whatnot. Bonuses, commissions, of course, are a big one for salespeople. Right, commissions are usually an extremely important component of an employee's compensation package. Commissions have to be included as part of the severance package. It's a no-brainer, right? And the same thing goes for bonus, and the same thing will go for benefits coverage, pension contributions. We can talk about significantly improved packages simply by including those different components of compensation alone. And that's another area, unfortunately, where employers will oftentimes seek to minimize their obligations and minimize what they offer employees. Oftentimes we'll see severance packages based on base salary only, right? Where even benefits or even things like pension contributions that are basic employment law 101 things not included as part of the severance package. Completely unacceptable on the part of employers. And that's where we as employment lawyers step in and make sure that employees are getting what they're actually owed when it comes to those items, when it comes to bonus. So excellent question, Trent. I very much appreciate you asking for it. It's really something else that you need to keep a very close eye on when it comes to calculating an employee severance entitlements. All right, we've got about 7 minutes left, guys, and I've got a few more questions to go through here. Once again, just for those of you tuning in for the last few minutes, my name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers in Ontario, in Alberta, and in British Columbia, answering any and all questions that our viewers have when it comes to employment law, when it comes to disability insurance law as well, and really anything under those two headings. Whatever situation you're dealing with at work, if you have a question, maybe you're just not on the same page as your employer, you're having a disagreement about something, maybe it's related to a bonus payment, maybe it's related to your position or a promotion or even a demotion maybe. If you're tuning in, go ahead and post your question very quickly. You don't have, keep it confidential. Don't tell me who your employer is. Don't give it out any personal information. Just post a general question. I promise I will get to it before the end of the segment in about 6 minutes or so. And you will feel a heck of a lot better having at least an idea, a framework of the way the law works in your particular situation. When you're dealing with a situation at work, the law cannot help you right? If you don't know what the law is and you don't know the way the law applies to your particular situation. So share with me that particular situation, and I will tell you whether the law can help you in those particular circumstances or not. You can often find, and it's surprising to many, our employment laws in Ontario and generally across Canada are actually quite favorable to employees. They're quite protective of employees. But again, the law can't help you if you don't know what the law is. All right, next up, Philip asks, if I'm starting to have increased pain due to arthritis in both hands, and I feel like I feel I may not be able to continue to work, over 50 years old, 15 years with the company, would I have severance? Interesting question, Phil. The first thing I do in your situation is speak to your doctor about potential accommodations. So rather than feel, Phil, as though you have to completely give up your job because you're starting to have some health issues, the first question I would ask myself if I was you is there a way that you can be accommodated in the workplace because of your medical condition, because of your arthritis, right? Maybe it means that you need to take more frequent breaks at work, right? Or maybe it means that you have to do slightly different kind of work than what you're currently doing. Or maybe it's you need to limit your number of hours that you're working a week. I mean, there are a host of potential solutions if you're dealing with a health issue at work where you can keep employment, you can keep your full pay, but just slightly rejig the terms of your employment or your job responsibilities, right? So the way you do that is not by just asking your employer to do that for you. No, you need your doctor's support. And actually, you need those requests and those kinds of accommodations to come from your doctor, not from you specifically. So make an appointment with your doctor. Speak to your doctor about a game plan as to how you can continue your employment, but with some accommodations, with some tweaking to make sure that you're able to continue working, but in a pain-free way, or at least in as much as possible a pain-free way, right? That's step number one. Your employer, Phil, has an obligation to accommodate any health restrictions or medical disabilities that you have. They cannot say in response, no, sorry, Philip, we can't we can't adjust your position, or we can't provide you with another position just because you're having health issues. It's not that easy for an employer. They have to play ball. They have to accommodate you to what's called the point of undue hardship, which is a very high bar. Actually, an employer has to do a lot before they can refuse to help an employee who's having a health issue. So speak with your doctor. Phil, listen, if you eventually get to the point where you have become effectively permanently disabled, right? You cannot work in any capacity whatsoever because of your health condition. If you are in Ontario, Philip, you would be owed severance in that kind of situation, but only if you effectively are permanently disabled and you're not able to work at all. Until you reach that point, and listen, hopefully you never reach that point, Philip, but until you reach that a point, the question should be, how can your employer accommodate your health restrictions? And make sure you have your doctor's support, and ultimately that you get a note from your doctor and send that to your employer, setting out what those accommodations should be. If your employer doesn't play ball, Philip, and they either refuse to accommodate you or they're giving you a hard time, that is when you give us a call, right? And we can talk about potential recourse in a situation like that. Again, keeping in mind that your employer has to accommodate you. We will leave it at that, folks, only because we've effectively run out of time. For those of you who've asked questions that I haven't answered, my apologies, but tune in tomorrow at 1:30 Eastern time. We will have another Q&A starting then. Go ahead and post your question at that point in time, and we can pick up where we left off. Until then, hopefully I was able to assist some of you today. Have yourselves a great rest of the workday and a great rest of the week. Until next time, so long. Take care, everyone.